Hey, welcome everybody. Welcome to today's episode of the Law of Self-Defense Show. Welcome. Coming in, make yourselves comfortable. And sorry about the couple minutes delay getting started, but that's how things happen sometimes. It is, after all, Monday. So we have some exciting stuff to cover today. We've been covering, of course, the Louis Casado self-defense immunity win in Florida. Just late last year, they had a series of self-defense immunity, a self-defense immunity hearing over several days. This was a case in which Louis Casado was standing outside a bar about 1:30 a.m. in St. Augustine, Florida, when he was accosted by a gentleman, Adam Amoya, I guess is how you pronounce his name. And one of Adam's buddies, they both began slapping Casado around on the sidewalk pretty viciously, to the point where Casado got backed up against the wall, drew his legally carried pistol, fired 7 rounds. 5 of those would strike Adam Amoya with fatal results. Casado would be charged with manslaughter by Florida prosecutors, and he demanded, as is permissible under Florida law, a self-defense immunity hearing. A self-defense immunity hearing is a procedure by which you can, in effect, get an expedited, lower cost, lower risk finding of self-defense, a legal finding of self-defense, without having to go to a full-blown trial. Full-blown trials are very time-consuming. They can take easily a year, 2 years, 3 years before you get to an actual trial from the time when the use of force event happened. They are very expensive. It's not unusual in my practice. Cases I'm consulting on, killing cases, so murder, manslaughter cases, for the defense to burn through a couple of $100,000 before they even get to trial. That's pre-trial expense, folks. And then things just go up in price from there. And of course, they're very risky. The trial, you have a final adjudication. Maybe you're acquitted, but if you're not, you're sentenced for a killing crime. Under Florida law, they have a very aggressive firearm sentencing enhancement statute, commonly referred to as 1020 life. If you commit a crime of violence, and they have an enumerated list of such crimes, and certainly manslaughter is among the list. If you commit the crime of manslaughter and you're merely in possession of a gun, you never discharge the gun, it's a mandatory minimum of 10 years in prison. If there are multiple counts, the counts have to be served consecutively, so 10, 10, 10 in a row. If you discharge the gun but don't hurt anybody, it's a mandatory minimum 20 years in prison. And again, if there's multiple counts, they have to be served consecutively, 20, 20, 20, one right after the other. And if you do discharge the gun and cause serious bodily injury or death, it's 25 years to life. And again, if there's multiple counts, it's multiple sentences served consecutively. So Louis Casado here was looking at life in prison. He committed manslaughter with a firearm. I mean, he never denied it. He stayed on the scene, waited for the police to arrive, and that has argued self-defense from the very beginning. And certainly there's substantial evidence here of self-defense. Nevertheless, the prosecution charged him with manslaughter, decided they wanted to bring him to trial. Now, at that trial, the burden is on the state to disprove self-defense beyond a reasonable doubt. If they can't do that, it's supposed to be an acquittal. So it's not enough for the jury to think, it probably wasn't self-defense. We really don't think it was self-defense. Self-defense has to be disproven beyond any reasonable doubt for the state to have met its burden in defeating Louis Casado's claim of self-defense. That's at trial. But of course, the state doesn't have to disprove self-defense in its entirety. The state has to disprove any one of the required elements of self-defense. Let me change my little avatar name here. Whoops, that's not what I wanted to do. Let's see. I'm trying to be better about this. The state doesn't have to disprove the claim of self-defense in its entirety. They need merely disprove any one of the required elements of self-defense. Any claim of self-defense, defense of others, any claim of defense of persons consists of a set of discrete elements, up to 5 elements of a claim of self-defense. Those are innocence, imminence, proportionality, avoidance, and reasonableness, as listed here. Folks, you can get this cheat sheet, this 5 elements of self-defense law cheat sheet from us for free. We don't charge a penny for it. It provides a list of those 5 elements and a brief description of them. If you don't understand these 5 elements, you can't possibly understand use of force law, defensive persons law. And you can get this for free. It's just a PDF download. Doesn't cost a penny at lawofselfdefense.com/elements. So what the prosecution has to do is, in all these elements, by the way, there's up to 5. Often not all 5 are required. Under this case in Florida law, in an otherwise lawful case of self-defense, Florida does not require the element of avoidance. Florida is a stand your ground state. Florida does not impose a legal duty to retreat before you can defend yourself in otherwise lawful self-defense. That would cover the element of avoidance. It's taken off the table under Florida law because Florida is a stand your ground state in an otherwise lawful case of self-defense. So in this case, we're really only talking about 4 elements. Avoidance is off the table. We're talking about innocence, imminence, proportionality, and reasonableness. And each of those 4 elements is a target of attack for the prosecution. The prosecution has to disprove one of those 4 elements, any one of them, beyond a reasonable doubt at trial, and they've defeated the claim of self-defense. If you're missing one of the required elements of self-defense, you don't have self-defense, because it has a minimum number of required elements. If one of the required elements is missing, as a strictly technical matter, whatever your use of force was, it cannot qualify as self-defense under the law. So at trial, the prosecution here would have to disprove one of those 4 elements: innocence, imminence, proportionality, reasonableness, beyond a reasonable doubt. But we're not at trial yet. We're at a pretrial hearing, a self-defense immunity hearing, often mistakenly referred to as a stand your ground hearing. Please don't call it that in my presence. I will get very upset. There's no such thing as a stand your ground hearing. You don't need a hearing for stand your ground. Stand your ground is just the law. Florida does not impose a legal duty of retreat. So everybody who's acting in otherwise lawful self-defense and meets the conditions for stand your ground qualifies. You don't need a separate hearing for that. Immunity, you have to qualify for. Someone has to make a determination of whether you meet the conditions for self-defense immunity. That's what this pre-trial hearing is for. And in the pre-trial hearing for self-defense immunity, it's basically a mini trial before the trial. So the state will argue against self-defense immunity. We've covered the state's arguments in the last few live shows late last week. Then essentially the state rests and the defense presents its argument in favor of self-defense immunity. And the judge acts as both the finder of law, normal role of the judge, and the finder of fact, a role that would normally be played by a jury at trial, but we're not at trial yet. There is no jury selected here. This is a pre-trial hearing. So we don't have a jury. It's more like a bench trial where the judge is playing the role of fact, finder of law and finder of fact. So, of course, facts are being presented. Witnesses are being presented. Claims are being made. Testimony. Experts are being presented. We'll see a whole bunch of experts from the defense coming up. Because we're at the point now where the state has rested and the defense is beginning to, with today's show, we'll be following the defense presenting its argument in favor of self-defense. The only real expert that the state put on was the medical examiner, whose testimony was very favorable to the defense. In fact, so far, every witness presented by the state that I've seen has been favorable to the defense. Now, in fairness, the first day of the hearing, the live stream is not available. The video stream of that is not available. I don't know why. I talked to the defense counsel about this. They don't know why either. So I didn't get the chance to hear the state's first day's worth of witnesses, but there were anything like the second day's worth of witnesses, some of whom were eyewitnesses, friends of the victim. And the medical examiner who did the autopsy, the testimony was quite favorable to the defense. Now, I mentioned at trial, the state has the burden of disproving one of those required elements of self-defense beyond a reasonable doubt. The state also bears the burden of disproof here at the self-defense immunity hearing not by as high a standard. So the common thresholds of evidence applied in a courtroom are preponderance of the evidence, beyond a reasonable doubt, which is all the way up at the top. That's the highest degree of burden. And then there's something called clear and convincing evidence, which we don't have a good definition for, but it's something between preponderance, which is 51%, and beyond a reasonable doubt. Let's pretend beyond a reasonable doubt is 95% of the evidence. So clear and convincing evidence is something in between. Let's call it 75% of the evidence. In a self-defense immunity hearing under Florida law, not all states apply the same standard, but under Florida law, the state has the burden of disproving self-defense in that hearing by clear and convincing evidence. So we're calling that 75% of the evidence. It's a lower burden than they would have a trial where they have to disprove self-defense beyond a reasonable doubt. But if they can't even disprove it by clear and convincing evidence, really, what would be the point of having a trial? If they can't do it to a lower standard, why would you think they could do it to a higher standard in a full-blown trial? So that's where we are in the self-defense immunity hearing. The state's presented all its witnesses, made its arguments. Now it's rested. Frankly, I don't see them having disproven self-defense by convincing evidence now. And in theory, this is the high point of their argument, because until now, we've not really heard from the defense, except, of course, on cross-examination of witnesses. And by the way, the defense has been fantastic on their cross-examination of witnesses. They've just been doing a great job. And in fact, I have some very, very exciting news I'd like to share with all of you. An oddity of self-defense immunity hearings that some of you may find surprising is that if the immunity is denied, so the defendant loses in the self-defense immunity hearing, and if you lose at the immunity hearing, off the trial you go. And one of the benefits of the immunity hearing is it's much lower cost than a full-blown trial. It's faster than a full-blown trial. Generally speaking, I mean, this one's kind of long with several days of hearing. But generally speaking, they're less cost, faster than a full-blown trial, and much lower risk, because if you lose a trial, you're convicted. And in a case like this, you're looking at 99 years in prison. And as far as appeals, forget it. I mean, appeals, less than 1% of appeals result in a favorable outcome. And a favorable outcome on appeal is not, they tell you you're not guilty. A favorable outcome on appeal is it gets remanded for a new trial and you get to do it all over again. And you're probably broke from the first trial. So your prospects for winning when you're devoid of resources in a second trial are not better than in the first trial. But if you lose a trial, you're convicted. You're looking at a 99-year sentence here. In the immunity hearing, if the defendant loses in the immunity hearing, doesn't get immunity, well, he still gets another bite at the apple. He still goes to trial. In fact, he goes to a trial where the threshold is more favorable to him, right? At the immunity hearing, the state had to have 75% of evidence against self-defense in our little model here. At the trial, the state has to have 95% evidence against self-defense. So it's a heavier burden on the state at trial. But one oddity of these immunity hearings is if the defendant loses, does not get granted immunity, he can't appeal that decision by the hearing judge. There's no appeal for the defense if they lose at an immunity hearing. But there is an appeal option for the state if they lose in the immunity hearing. And why would the outcome be different there? Well, the way the appellate courts have decided this is, hey, if the state loses, that ends the legal process for this case. It's the final decision in the case. So because it would otherwise be final, we're going to allow an appeal. If the defendant loses in the immunity hearing, well, there's still a trial to follow. So the process can just continue. We don't have an otherwise final outcome. So we're not going to allow an appeal for the defense. Seem fair to you? I don't know, but that's the way they do it. So here, of course, we know that Louis Casado won his immunity hearing. We have the order for that. It was handed down December 30th. So a nice New Year's Eve present for Louis Casado. But because the defense won, there is an appeal possibility here. In fact, the state has until Thursday of this week to appeal that decision, 15 days roughly from the order granting immunity. So we're still in a period where, in theory, the state could file an appeal. But that ends Thursday. So Friday, the immunity is locked in for Louis Casado. There's nothing the state can do about it. And as it happens, I've managed to finagle a pair of very, very special guests. See if I can find my little screen here that I need. The actual defense attorneys for Louis Casado. That's Dan Hilbert and Pat Kanan. These are the gentlemen who've been working the defense in the self-defense immunity hearing, and they have kindly agreed to come on the Law Self-Defense Show on Friday, this Friday, January 20th, to spend some time with us discussing this self-defense immunity win. And I have to say, this was all arranged with the invaluable help of our good friend, attorney Steve Gosney. who works in the same judicial district, is familiar, friendly with these attorneys, and thinks very, very highly of them, by the way. Steve does. So I'm very, very excited. So be sure to mark in your calendar this Friday. It's at 3 p.m. What did I put here? That's wrong. I have to fix this. It's 1 p.m. Oh my gosh, no, it is. It's 1 p.m. Eastern time. That's correct. 1 p.m. Eastern time, we'll be interviewing attorneys Dan Hilbert and Pat Kanan, the defense attorneys in this Louis Casado self-defense immunity win. Video and audio live stream with these attorneys. So that should be a great deal of fun. Listening to their in the trenches perspective of what it was like to fight this battle and win it for their client. So very excited to be able to bring them on board for that. But today we're still playing catch up. So these self-defense immunity hearings occurred in the middle of November of last year, and the order granting immunity, as I said, was December 30th. So while you're watching me live, if you are watching me live yes, all right. Let me just check the streams real quick to make sure everything is in fact working correctly. All right, so YouTube is working. Twitter is working. Let's see. Law Self-Defense Membership Dashboard. Of course, I should have done this first. Come on, baby. I have to check the tie in the image to make sure I'm looking at the right one. That's working. And the Rumble stream also working. All right, so we're streaming everywhere. So today, we're still playing catch up on the hearings, video of the hearings from November. Today is the second day of those hearings, but it's the third part of our covering the second day. This is the part where the state has just rested, and we're going to begin to see the defense on offense. Now the defense team gets to call its own witnesses, its own experts. A lot of good-looking experts here, good-looking in terms of, I'm sure they're physically attractive as well, but good-looking in terms from a legal perspective. And until now, the defense has been limited to cross-examining the state's witnesses, but now the defense gets to go on offense. So that's all extremely exciting. So let me make sure I have that, the video, the proper video. I got to get that spooled up. Where are you? Proper video. Looks like I accidentally closed that, but I'll get her back right now. Let's see. We finished yesterday with a police officer who was part of the investigation. A waitress, a restaurant manager, and then the corporal. And again, all their testimony was, it was not inconsistent with self-defense. Okay, now I've got it spooled up to where we're ready to start with the trial itself. Of course, I should mention up front, I'm happy to answer questions as they come in, but questions have to come in one of two forms. The least favorable and most costly for you form is as a super chat. So if you're watching this on YouTube, you'd like to post your question on YouTube, it needs to be in super chat form, a minimum of $5. And that's what helps me distinguish it from all the background chatter. Or alternatively, what I would actually recommend is that you simply become a Law of Self-Defense member. Then you can watch this in the Law of Self-Defense member dashboard and pose as many questions as you would like in that Law of Self-Defense member dashboard, and do it for free, for no cost above your membership. In fact, right now, we're running a 99-cent trial on our membership. Normally, the membership's less than 30 cents a day, about 30 cents a day, I guess. It's less than $10 a month. But if you want to try it for 2 weeks, see what it's like, you can try it for 2 weeks for 99 cents, have all the privileges of a normal member, access all our content, thousands of, well, certainly many hundreds of videos, podcasts, blog posts, and you can ask as many questions as you like without having to pay super chat fees. In fact, you may even get police sirens in the background. That's one of the benefits of Law of Self-Defense having an office. about 3 blocks from the local police station and a block from the fire department. So we get not only train noises here, folks, but we get lights and sirens as well. But you can try out a law self-defense membership for 99 cents. If you don't like it, folks, cancel in the 14 days and we'll give you double your money back. I mean, it's only, what, $1.98, but still, we didn't ask for much up front. And if you just stay a member, well, then it turns into the normal less than $10 a month for the membership. And you can do that right now. Try it out at lawofselfdefense.com/trial. That would be the other way for you to pose questions in the Law of Self-Defense member chat. And without having to pay $5 minimum super chats and without having to give YouTube cash. YouTube, of course, takes roughly 30% of all that super chat money. And YouTube's got enough money, don't you think? The other thing I wanted to mention, a couple of things. One is we have one of our relatively rare, we only do this class once or twice a year, Law of Self-Defense Advanced courses coming up. This is our, here we go, full day Law of Self-Defense course, the same course I taught for many years traveling around the country. We do it on a Saturday. This one will be Saturday, April 15th, tax day, 2023. So it's coming up shortly. This is our full day advanced course. We cover all the 5 elements of self-defense in the context of real world trials. We cover interacting with the police in the aftermath of a use of force event. We spend an hour just on that, interacting with the police in the aftermath of a use of force event. We talk about defense of others. We talk about defense of property. We talk about how the criminal justice system really works, how it really evaluates a case of self-defense, the weaknesses, vulnerabilities the system looks for in your claim of self-defense, and therefore what you should avoid building in to your use of force event, and lots more. We teach this class once, sometimes twice a year. So we don't have a second one scheduled yet, but we do have this one, April 15th. And the good news, the great news, is if you sign up for this course this month in January, you get 50% off the normal registration. You save about $100. If you sign up for this class next month, it's 25% off. If you sign up for this April class in March, it's 10% off. And of course, if you sign up in March, it's just the normal full price. So if you'd like to get the best possible deal on this, I would encourage you to sign up sooner rather than later. And you can do that at lawofselfdefense.com/advanced. And finally, don't forget our book, great book, Law of Self-Defense Principles, the softcover edition. You can look this up on Amazon. Over 1,200 reviews, 5-star rated. People love the book, but don't buy it on Amazon. They'll charge you $25 plus shipping and handling. Get the book from us, and we eat the cost of the book. We do ask you to still cover the cost of shipping and handling. We have postage. We have guys in the warehouse who have to pack this stuff up. They need to get paid, but we eat the cost of the book. And you get your free, and it's a real book, folks. It's not some BS PDF download. It's a real physical book, 200 some pages. Get it at lawofselfdefense.com/free book. In fact, we're just about to order another several 10,000 copies of the Law of Self-Defense Principles, I am told. All right, so I think that's all the housekeeping I had to do. Let's do this and this. So we're at the point now in this proceeding, this self-defense immunity hearing, where the defense is about to go on offense. And before I jump into that, let me actually take a moment to look and see if there's any questions I already need to answer. And there are. All right. So Law Self-Defense member chat. The members get to ask all their questions for free, folks, at least nothing beyond the cost of their membership, which again is less than $10 a month. And you can do a 99-cent trial of that right now of membership at lawofselfdefense.com/trial, as you can see right below my head here. So the usual suspects in the member chat, the old reliables. Welcome, folks. Welcome. Really appreciate it. Let's see. Law Self-Defense member Kansaki asks, question, can the defendant get legal fees for winning a self-defense hearing? No. Nope. Florida doesn't do that. There's really no state where you can get legal fees except one. The state of Washington does have a provision for a defendant who's charged in the use of force crime and raises the legal defense of self-defense to get the state to recompense him for all his legal expenses. And how that works in Washington state is if it's a Normally, if you're charged with murder because you shot somebody, you claim it was in self-defense, you argue self-defense at trial, you get acquitted. Usually, we don't know explicitly why you were acquitted. The jury's not required to say, yeah, we're acquitting him on self-defense. That's not how it works. They just have the jury form for the crime and they check off guilty or not guilty. Maybe they're acquitting you on the grounds of self-defense. Maybe because they're engaging in jury nullification. Maybe because they're feeling kindly disposed. They like the way you look in the courtroom. I don't know. Nobody knows. The jury doesn't have to give any specific reason why they acquit. We would presume in a self-defense case that if self-defense was the only legal defense, that would be why, but we don't actually know in any concrete way. Well, in the state of Washington, they actually have a provision that says, hey, if it's a use of force case, manslaughter, murder, whatever, and the legal defense raised is self-defense, the defense can request that there be a special jury form given to the jury. And that jury form says, hey, members of the jury, do you agree that the state failed to disprove self-defense by a preponderance of the evidence? And if they do agree, in other words, they believe, they agree, they explicitly say, they sign on that jury form, yes, we believe the state failed to disprove self-defense by a preponderance of the evidence. Then if that special verdict form is signed by the jury, the state of Washington is obligated to reimburse the defendant for his legal expenses. I think that's a fantastic provision. I think every state should have it. But unless you live in Washington state, that doesn't exist. So there's no means to get your legal expenses covered. Now, if you were a member of CCW Safe, for example, you could get your legal expenses not just reimbursed, but they'd be covered up front. Let's see if I have a little image for that. Oh, I used to. Let me look here. Well, I don't have it handy anymore. But if you wanted to become a member of CCW Safe, CCW Safe is what many people refer to as self-defense insurance companies. They're not a self-defense insurance company. None of these organizations, CCW Safe, USCCA, Law Shield, none of them are really insurance companies. But the idea is that they promise to cover some or all of your legal expenses if you're involved in a use of force event. The only one of those organizations I feel comfortable recommending anybody consider is CCW Safe. I do, full disclosure, I do quite a bit of partnering with them. I think they're a great organization. I consider the people who run that place to be friends of mine, personal friends of mine. So consider that, and perhaps that introduces a bias, but I've chosen them to partner with because I think they're the best organization out there on the merits. And not just because they do, in fact, they don't just say it, they actually do it, cover your legal expenses, but they do more than these other organizations. For example, they have a team of experienced, retired, very experienced homicide detectives out of Oklahoma City, where they're based. And these guys are, decades of experience as investigators. They fly in to wherever your use of force event happened. They get on a plane, they fly into you. So you have your own investigators on the scene. If you don't have something like that, folks, the only investigators on the scene work for the prosecution. That's not great. So lots of reasons why I recommend CCW Safe. And so if you're interested in that, I would encourage you to point your browser to lawofselfdefense.com/CCW Safe. And if you use the discount code LSD10, you can get 10% off your membership with them. That's LSD for Law Self-Defense, LSD10 at lawselfdefense.com/CCW Safe. Now, listen, none of these plans are what I would call inexpensive, and everyone's circumstances are different, right? For some of you, the money would be better spent on, ammo, training. I don't know what your situation is. For some of you, you may be wealthy enough that, you're not worried about the legal expense. You can basically self-insure. But for a great many people, there's a lot to be said for having that financial backing if you're charged in a use of force event. Like I said, and if you've killed someone in self-defense and you're being tried, you can easily spend a couple $100,000 pre-trial. And it just goes up from there. And I'd like to be able to say that the kind of justice you get is not impacted by how much money you have, but folks, the resources matter. It's like any other fight, any other battle. So something to think about, lawselfdefense.com/CCWSafe. Let's see. Question. What happened to the Florida Supreme Court ruling holding that the proper remedy for appeal of a motion for dismissal on the grounds of immunity was a writ of prohibition? I believe I've read a number of Supreme Court opinions in such appeals. Donnie, I don't know. I don't follow Florida appellate law on these immunity hearings at that level of detail, unless it were to come up in a case where it was actually being argued. Then of course I would refresh my recollection. But I expect we'll have Steve Gosney on again sometime soon. Steve is working, attorney Steve Gosney, a public defender down in Florida, fantastic attorney, close friend of mine. Steve is currently on a capital case down in Florida. So he doesn't have a lot of free time at the moment, as you might imagine. Literally life is at stake in the case he's working on. But we'll have him on as soon as he's available, and feel free to bookmark that question in your mind. I'm sure we can pose it to Steve, and Steve would have a well-informed answer. All right, so that's all the member questions that are currently in place. Let me take a look and see if there's any super chats that have already come in. It does not look like it. Those are from a couple days ago. All right, folks, let me take a sip of coffee. And many thanks to Shane here again as a moderator on this thread. Often this would all be much, much more difficult much more difficult without Shane's involvement. It looks like Von Klein is in the chat. Hey, Von. Von is from, if he's still associated, but I know him from Force Science Institute. If you don't know Force Science Institute, they do a great job doing research on and studies in a far more concrete way on use of force, events, dynamics, how people react, response times of people, vehicles, all kinds of stuff. They do in a very I was going to say academic, but academic these days is often interpreted derogatory. I mean, a very disciplined scientific method kind of approach on these events. They have a bunch of papers for free, freely available, I think, as PDFs on their website. Always very interesting reading. And I am a graduate of their Force Science Institute, their week-long class a couple of years ago. I think I took it in Dallas. And it was great stuff. I really, really enjoyed that experience. Very, very insightful. Let's see. Is Steve in the chat? Oh, he is. You're supposed to be working, dude. Hey, Steve, I'll send you the invite, and you can let me know if you have the time and interest to join in at any point. A lot of this is just going to be watching witnesses, but you are, of course, welcome at any time. Let's see. All right, so that is off to Steve Gosney. And if he pops in, I'll be happy to add him. All right, so with that out of the way, oh, folks, of course, let me take a look here. What do we got for likes? What do we have for likes? Why can't I see this? Almost 400 people watching, only 125 likes, folks. Hit that like button. Hit that thumbs up on YouTube, folks. We don't charge for these shows. The least you could do is hit the free like button. That's one of the most important facets of the YouTube algorithm for sharing our content with a broader audience. So I would really appreciate it if you could hit that like. If you're not yet a subscriber, we just broke 46,000 subscribers. It would be great to hit 50. Again, that helps encourage YouTube to spread our content more broadly. And that's our mission here. That's why we do these shows, is to get this information out to more people. So hit that subscribe button. If you haven't already, help us break 50,000 subscribers. That would be amazing. Considering I don't really consider myself one of the law tubers, but that would be awesome. And please hit that like button. Greatly appreciated. All right, so we're going to start now with let me put the volume up. And I'm going to crank the volume, folks, as loud as I can make it. So you don't need to tell me the volume's low in the courtroom. I know I don't control the courtroom's audio system. I'm doing everything I can on my end to crank up the volume. And there we go. So that's cranked up 600%, and I'll work what I can with my soundboard on my end, and hopefully we can make all this happen in as useful a way as possible. Let me do this. And with that said, we're going to start now. This is day 2 of the hearing. The state's gone for pretty much a day and a half, presenting their witnesses, including the medical examiner, investigating officers, eyewitnesses to the event. Frankly, none of what I heard was evidence inconsistent with self-defense. I think the only straws the state really has to work with here is one that Casado had been drinking in the bar. We don't have a blood alcohol level for him. We do have a blood alcohol level for the person who attacked Casado, 0.266. That, folks, is juiced. So Adam Amoya was very drunk. He was also on Oxy, and Oxy potentiates with alcohol, meaning they each escalate each other's effects. So in effect, even drunker than a normal 0.266, which is pretty soused. That's 3 sheets to the wind. And then add Oxy on top of that. It's effectively a higher blood alcohol level. But Casado had drinks. He's on surveillance camera having drinks. There's receipts from the bar. He had a couple drinks, maybe 3, 4, 5, 6 over a several hour period. And some of the rounds that hit Adam Amoya, including what was probably the fatal round, entered his back, Amoya's back. So it would appear from the hits, there's a couple in the front, there's one in the shoulder, there's one in the flank, and then there's one that enters through the back that Amoya might have started twisting his body away from the muzzle of Casado's gun as the shots were fired. Casado had his glasses knocked clean off his face by the first slap, open-handed slap to Casado's face. And we'll hear in upcoming testimony that Casado's vision was pretty bad, maybe 100 or 200, at the best 20/80. So it's quite possible that when he lost his glasses, he was effectively blinded at that point. May not have even known he was shooting into the back of Amoya. But in any case, that shot went into the back, pierced the heart, pierced the aorta. Those are really non-survivable injuries at that point. So the state may feel they have an argument to be made based on the fact that Casado had been drinking, and what was probably the most immediately fatal shot was fired into the back of the victim. Frankly, it's all easily explainable away as being consistent with self-defense, but that was the most favorable of the evidence I heard in the hearing so far for the state. Is that disproving any element of self-defense by clear and convincing evidence? I don't think so. Not in the broader context. But of course, the broader context now has to be presented by the defense here, which is what we're about to see them do. The state's rested. The defense is about to begin presenting their experts here. And we do have a list of the experts we can expect. If the witnesses are going to be presented in the same order that they were discussed in the court's immunity order, and so far they have been. So the witnesses we should expect to appear for the defense include several people whose are not identified as to function. I presume they were eyewitnesses. Then Dr. Charles Samuel Miles, an optometrist, expert witness, presumably for the defendant's vision or impaired vision, especially after the glasses have been knocked off his head. Charles Brian Moody, another expert witness on accident reconstruction. Presumably, he'll do some kind of analysis about the distance between the parties and obstacles and so forth. Paris Ward, another expert witness, forensic video analysis, because this was captured on video. Nicholas Ray, doesn't say what his role is. Corporal Nicholas Argytis, presumably an investigator here in this case. And Dr. Roy Bedard, another expert witness. We're familiar with Dr. Roy Bedard. We've seen him testify as a use of force expert in other trials. Generally does a pretty good job, generally. Dr. Deidre Leak, a facial plastic surgeon, another expert witness. And finally, Dr. Lawrence Miller, a psychologist, presumably another expert witness. So we have the defense presenting here 1, 2, 3, 4, 5, 6 expert witnesses in this self-defense immunity hearing for the defense. Guess what, folks? All those expert witnesses are paid, and they're paid well. So when I tell you that it's not hard in these cases to spend a couple $100,000 before trial, this is one of the reasons, folks. You'll spend a lot of money on 6 good expert witnesses, a lot of money. And one of the reasons how much money you have affects the justice that you get from the system is because if you have the money, you get 6 expert witnesses. And if you don't have the money, they don't show up because they don't work for free and you don't have them. And that expert witness testimony can well be vital, decisive in whether you get self-defense immunity or whether you're acquitted in the trial. And if you don't have the kind of money to pay for these kinds of expert witnesses yourself, that's one of the places where somebody like CCW Safe can make all the difference. Because guess what, folks? If your lawyer, your defense counsel says, hey, I need these 6 expert witnesses, and that's going to be a giant bill, CCW Safe pays the bill. I mean, they don't think twice about it. And again, you can learn more about that at lawofselfdefense.com/CCWSafe. And if you use, again, discount code LSD10 will get you 10% off your CCW Safe membership, which is always nice to get a discount. So those are the witnesses we'll expect to hear. We'll go through, let's see, the end of today for sure. How long is this video segment? We are at... So it's about 2 hours, 20 minutes here. So we'll certainly, in today's live show, we'll go through this 2 hours, 20 minutes of the rest of this day 2, and then we'll probably pick up a successive show for day 3. All right. And with that out of the way, here we go.
Yes, thank you, Judge. One of the things that I realized earlier was when we placed the State's Exhibit 4 into evidence.
This is the prosecutor here. He's just doing some administrative stuff, clarifying and labeling the evidence.
All the photos were the same. They were just in a different order. So I have made a copy of the photographs in the right order as they were displayed, as we would have called out these numbers on the record. And I've given those to the court reporter to replace the ones that were placed in evidence before. I spoke to Mr. Kanan about it. He didn't have an objection for us replacing that. But I wanted to be sure you were aware of what we were doing.
The photographs are the exact same photographs, they're just in a different order. Mr. Kennedy, do you agree with that?
I do agree.
We object then was replacing that item of evidence with the properly.
So on the left here, we have the prosecutor whose name I'm blanking on. I'll refresh my recollection on who that is. I had been told, let's see. I just don't remember. But this is I refer to this defense attorney in the bluish suit here as Kanan. I guess according to the prosecutor, the appropriate pronunciation is Kanan. So that's one of the 2 defense attorneys there. The other defense attorney has a bearded appearance. In fact, I can pull up them now just briefly. This is them. That's Kanan on the right. Guess he likes blue suits. And Attorney Dan Hilbert on the left here is the other defense attorney that we'll see in the courtroom from time to time.
Do not object. Just go ahead and replace that with the proper identified. What we'll do is we'll hold on to the other one as a core exhibit, I guess, just to make sure that there's a record for whatever reason is necessary. But we'll go ahead and have that one marked as number 4.
Number 4. I just want to be sure the record was consistent with
the testimony of the witness.
That's correct.
Okay. All right.
Judge, can I ask you a timing issue?
Yeah.
We're prepared to call 3 witnesses right now. Actually 4, but one of them for some reason is not here, but under subpoena, so we're hoping that she comes. That's gonna take us probably not till 5 o'clock. I have an engineer prepared to drive from Jacksonville down here, but we would definitely be going over 5 o'clock if we call him today, or with your permission, I would ask him to be the first witness at 9 in the morning.
About 9.
So that's Dan Hilbert, Attorney Dan Hilbert, on the other side of Attorney Canaan, the second defense attorney here.
And maybe there is that.
Yeah, whatever.
What is, tell me a little bit more about what you envision for the rest of your.
I think we're gonna have
So we get finished.
1, 2, 3 relatively short witnesses, and then Mr. Casado's eye doctor, which could take a bit of time.
That would be today,
Yes,
and what about tomorrow?
tomorrow would be, this gentleman I'm talking about from Jacksonville would start, and then we have a videographer expert from California that would be second, and then there's additional witnesses from there.
How much more time are you gonna need? Are you gonna use all of tomorrow, are you gonna finish tomorrow, or?
I think we will use all of tomorrow, and then all the experts are lined up for Thursday morning, including the states.
Well, and I know that based on what they had kind of represented to me about what their plan was, I didn't see any way that we would have time to put anybody on rebuttal for tomorrow. I have one person coming from out of town, another person who testifying via Zoom from Tennessee. So I have told both of those, be prepared for Thursday in anticipation of the lineup as they kind of communicated that to me.
Okay, I don't mind if we break a little bit early today, but tomorrow I expect that we're gonna have a full day of witnesses, so if there's any, experts that need to be available from your side, we're gonna make sure there's somebody that takes to, it's very close to 5 o'clock.
Okay, I want to break this to you now, because most of my witnesses, they're all out of town, these experts. One's California, one's South Florida, and the other's Tallahassee. So I don't know if I could get any of them here tomorrow. I do believe that we can take up most of tomorrow, if not the whole day. I'm just not positive. I don't know, I don't think I can get, there's flights involved here.
All right, well, we will, just proceed, today with the witnesses that you have lined up, and we'll start back tomorrow morning at 8:45.
So, of course, this is just the judge, managing his courtroom. They don't like dead time. They don't like half days, 3/4 days. They want every day to be fully filled. And this is a pretrial hearing. And normally in a pretrial hearing, you don't have these complications. You don't have experts that need, half a dozen experts that need to be flown in and scheduled and all that kind of stuff. So you can see the judge is a little taken aback by how this has complicated his management of his courtroom, but that's just the way it is. By the way, folks, Steve Gosney has informed me that his computer is currently broken, so he's not going to be able to join us on the stream, besides being involved in a capital appeal right now. Sorry to hear that, Steve, but thanks for chiming in on the comments while you could.
The engineer from Jackson.
All right, thank you. Yes.
Madam Clerk, all right, finish your part first one.
We're going to call Christopher Wingate.
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 Good afternoon, sir. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? So help me God. Step one over here and have a seat for the witness stand, please. Just make sure that you try to speak into that microphone.
Good afternoon. Please state your full name,
Christopher Cletus Wingate.
and do you live in St. Johns County?
Yes, I do.
And how long have you lived here?
Close to 12 years now.
And what is your occupation?
I am a night auditor at a hotel.
Say that
A
again?
night auditor at a hotel.
And a night auditor at what hotel?
The Hilton Bayfront downtown.
And how long have you worked there?
Close to 10 years.
And what are the hours of a night auditor at the Hilton?
11 at night till 7 a.m.
And In the past year or two, has Louis Casado been employed by the Hilton?
Yes.
And how long did he work there approximately?
That I'm not sure, maybe 7 months.
And did he work there up until May 28th of 2021?
Yes.
Can you tell the judge up until May 28th of 2001, how many days in a row he had worked?
30 days.
And what were his hours?
Same thing, 11 till 7.
So he would
I'm
come-
sorry, 10 till 6.
So he would come to work at 10 in the night and then work till 6 in the morning?
That's right.
And he did that for 30 days in a row?
Yes.
So the night before May the 28th, he would have worked through the night?
Yes.
And as an employee there, is there kind of a uniform that you have to wear?
Yes.
Could you explain that, what that is to the judge?
At the time, we had a black jacket. Most of the front desk clerks had to wear a suit, a black suit that was purchased by the company. And the security staff at night had the liberty to wear it as well.
So black, it's all black was basically the uniform for the staff.
Yes.
All right, may I post witness to it? I'm going to show you what's been marked as Defense Exhibit I, and tell me if you recognize anybody in the photo.
So Louis Casado.
And does that appear to be an accurate representation of what he would wear to work?
Yes.
And I'm going to actually move this into evidence at this time, which would be exhibit number 5 for the defense.
Any objection? Let's go break this one.
I'll ask the publish.
We get it collected.
Yeah,
We'll
okay.
bring it to.
So this appears to be a photo, seeing it from the back here, it appears to be a photo of the group of men standing outside the bar where this confrontation occurred. And this is attorney Canan, defense attorney Canan, on direct of this witness, Christopher Cletus Wingate, who worked with the defendant.
Clerk, so we can have it marked. What was it marked for identification? That's what letter.
Identification I.
Identification I will be received into evidence as defense next under exhibit
Number 5.
All right, now you may vote.
Okay, thank you, Judge. Is this the picture that I just showed you?
Yes.
And does it accurately and truly represent what you would wear or what he would wear as staff at the Hilton?
Yes, that's pretty much what he wore.
That's all the questions I have.
Ross?
Just briefly. Good afternoon. You used the phrase when you were asked, now, tell me again, what you're the night auditor,
Mm-hmm.
and is that different than a security job?
Yeah, the security, what Louis was doing was security and valet, which was handling problems at the hotel or parking vehicles. I did more the hotel end with guests, checking people in and out of rooms, doing audits.
Okay, so the dark jacket, that was, or the suit, that was your uniform, is that correct?
No, it was put into place by Tom Mano. And before Louis got there, the night security had started wearing that suit as well.
Okay, I think what I'm trying to clarify, because you used the phrase, the security, and that's the role that Mr. Casado had at the hotel, correct? Was it-
Security slash valet.
I'm sorry,
Security slash valet.
valet?
Yeah.
And so you used the phrase, they were at liberty to wear that as well.
Mhm.
So you used that phrase, it seemed like that was optional, is that correct?
It was optional for the most part, but I mean, for the last 5-6 years, most of the security was wearing the suit. It was like the relief security on the weekend could wear like the uniform at the time. It's been a while, and they since have changed the uniforms. So
Well, specifically in May of last year, it was optional, so it wasn't like mandatory that you wear that.
mandatory, no.
Can you redirect?
No, sir.
So is the excuse?
Yes, sir.
All right, sir, thank you very much. Feel free to go.
All right, so that's Christopher Wingate. It appears the only reason for him to be there is to explain why the defendant was dressed in the manner he was dressed, and perhaps for the defense to emphasize that he'd been working 30 days in a row. Maybe that affected his mental state this evening. I don't know. But I guess they to be concerned that maybe they don't want. This will be a good question to ask these attorneys on Friday. Maybe they were concerned that their client would be perceived as thinking he was John Wick, for example. Maybe they were concerned that the state might try to run with a John Wick. He was looking to get a headshot in at the slightest excuse kind of narrative, which I wouldn't put past a prosecutor.
The defense calls Ricardo Ruiz.
Ricardo Luis.
Sir, if you could please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Sir, if you come around here and have a seat in the witness stand.
Yes, Your Honor. All right, good afternoon. Please state your name for the record.
It's Ricardo Ruiz, R-U-I-Z.
And what county do you live in?
I live in Flagler County
How long have you lived in Florida for?
since 2001.
And sir, what do you do for a living?
I am a security officer at Flagler Hospital.
And back in May of 2021, where did you work?
I worked at Dos Gatos.
And what was your role there?
I was head of security.
And were you there on the sort of the evening of the 28th, rotating into the morning of the 29th?
Yes, sir.
And what were your responsibilities that night?
I was checking ID at the door.
And that would have been that sort of gateway that enters into a lanai for the Dos Gatos.
Yes, sir.
And did you know Adam Moya prior to that?
Yes, sir.
And were you all personal friends?
We were acquaintances.
Did you know Luis Casado at that time?
No, sir.
Had you ever seen him at the bar?
Who? Who?
Mr. Casado.
I've seen him.
And then when the incident occurred, where were you at?
I was in the restroom.
So it's safe to say you didn't see the fight or the shooting.
Yes, sir.
Now, did you check Mr. Casado into the bar
Yes, sir.
and check for his ID and all that type of stuff?
Yes, sir.
And at that time, did he seem intoxicated to you?
No, sir.
Judge, that's all I have. Thank you.
Ross?
There you go.
This witness be excused.
Yes, Your Honor.
All right, sir, thank you. It was pretty good.
Another quick witness.
I anticipated things moving this quickly, Mr. Fernando, maybe we do need to get that engineered out there for Jacksonville. This is how fast we're gonna be moving. You want to go ahead and call them, and try to get them down here?
They can. Mr. Moody from Jacksonville.
It's only 5 minutes still through.
We have two more witnesses, Judge, before him.
They want you to come.
Okay, that sounds good. Who find next witness?
Would be Lindsay Dagler.
Lindsay Dangler.
Lindsay Degler.
Approach me. Stay right there, raise your right hand. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? Yes. You walk on over here. Watch your step. Come on up to the witness stand. Make yourself comfortable and try to speak into that microphone.
Okay.
Your witness.
Thank you, sir. State your full name
Lindsay Marie Degler.
and where do you live?
Full address,
No, just what town you
St. Augustine.
And how long have you lived in St. Augustine?
11 years.
And how are you employed?
Currently, I am not employed.
Back in May of 2021, were you employed then?
Yes,
And where did you work?
Dos Gatos,
And what was your job there?
bartending.
And were you on duty on May 28th of 2021?
Yes.
And were you, tell the judge what you were doing that night?
Bartending, serving drinks.
And we've heard of different wells of the
Mhm.
bar, Cascado's. Were you at a particular well?
For the most part, yes, but all over the bar was still my job. So
I see. And did you know of Adam Amoya?
yes,
And was he a regular at the bar?
yes.
And how often would you see him?
I would say maybe once every couple of weeks, but he didn't frequent when I was there.
I see. And did he have particular bartenders he would normally go to?
Yes,
And were you one of them?
No.
And on May 28th, did you serve him at all?
yes.
Okay, do you remember about what time?
Towards the end of the night, right at around last call, which would have been around 1:30.
And do you recall, did he order for you?
Yes,
And do you recall what he ordered?
Crown apple meat.
Shot?
Yeah.
Multiple shots?
I can't really remember, but my guess, I think it was either 2 or 3, but not for himself, but as a
Do you know
group.
if any of them were for him?
That I don't know, but he ordered 2 or 3.
Did you also, do you know who Louis Casado is?
I do now, yes.
Okay. And had you seen him before that night?
Not that I recall.
You did see him on May 28th though.
Yes,
And did you serve him?
yes.
And how many drinks did he have?
Again, if memory serves me correctly, 3.
And wasn't one of those discarded, however, because it was put behind the bar?
Yes,
So it really turned out to be actually 2?
that I served him, yes.
And could you describe to the court how his demeanor was at the bar that evening?
Not extraordinary, if that makes any sense, just a normal person interaction. I want to order this drink. I said, okay. Normal interaction.
Was he polite?
Yes,
Or was he hostile in any way?
no,
Did you see him interacting with any of the other patrons?
I did not know.
That's all the questions I have.
Cross-examination.
Thank you, Your Honor.
Please, witness be excused.
Yes, sir.
Thank you very much, and you are free to go.
Thank you.
All right.
Oh, God.
Okay. Dr. Miles. Dr. Miles.
I know he was on the way, he was working today.
So another quick eyewitness, no cross-examination on any of them. Well, I guess a little bit for the first guy about the uniform, but not the bouncer at Dos Gatos, the bar in question, or the bartender. Zero cross of them. A not very well, not the youngest bartender I've ever seen with lots of arm tattoos. That's a formula for success right there. Currently unemployed. Color me shocked. All right. The next witness being called now, I guess we'll see if he's available, but he's next in the sequence, is Dr. Charles Brian Moody. This is the optometrist for Louis Casado, who presumably will testify about his poor vision, especially poor once his eyeglasses have been smashed off his head by Adam Amoya in the first blow of this series of blows that Amoya and a friend struck at Louis Casado's head and face in the course of this conflict. So it looks like we're actually going to take a break. I think they're waiting for the optometrist to show up. So I'm going to, well, first of all, I'll put the closed captioning on for everybody. And I'll fast forward to to when the court comes back into session. So let's go ahead and do that. Oh, here we go. I'll also speed up the playback speed a little bit, 1.25. I don't know why this isn't playing. because the timer is counting down. All right, folks, I guess I just have to let it play until it gets to that point. Well, with those, okay, now the image is moving again. So I guess we'll start up. But as long as we're here, let me take a moment to see if any more questions have gone on. Well, Law Self-Defense member Steve says, CCW Safe member since 2015, and they haven't increased my rate from the original subscription, which I believe has been their policy. In addition, they regularly publish training material well worth the price. Yeah, I like CCW Safe, folks. Again, you can learn more about them at lawofselfdefense.com/CCW and use LSD10 to save 10% off your membership with them. There's training. There's a team of investigators. They fly into you if you're involved in a use of force event. They pay. They pay not only, first of all, they pay without cap your legal expenses. They don't stop covering your legal expenses if you're convicted. They pay for an appeal. They pay for a retrial. Very few of these other organizations do anything like that. lawselfdefense.com/CCW Safe. Let's see. Law Self-Defense Miles asks, how goes your BJJ? I have to say it's not going great. And that's because in the last quarter of last year, I had a couple of modest medical surgical procedures that kept me out of the dojo for a while. And I've gotten off track. But I am going back, I promise. In fact, I may be visiting Gracie University headquarters in Torrance, California, to teach a private law self-defense advanced class very soon. That's in the works. I'll let you know more about that as that develops. Let's see. Let's see if there's any super chats that need to be addressed before we get into the optometrist witness here. It looks like just one, not substantive, but he paid $5, so I'll read it. The Hot Dog Wizard. The Hot Dog Wizard looks like 2 Z's in Wizard. $5 super chat. And he says, I have under 30 followers on Twitter. Please don't block me. I have good comments, longtime supporter of the channel. So, well, I would encourage folks to check out the Hot Dog Wizard with 2 Z's on Twitter. Yeah, for folks who don't know, it's been my experience on Twitter, and we have, I don't know, how many followers do we have on Twitter now? Let me take a look. Just over 66,000. But there's a lot of nonsense on Twitter. A lot of trolls, a lot of bot accounts, a lot of propaganda accounts. And in my experience, almost all those malicious accounts have very few followers, like 0, 1, 2 followers, certainly less than 100. And they spout nonsense. They just spout propaganda, or they're just hostile. So I'm very, very quick to block those accounts on Twitter. Now, you can have a low follower account on Twitter and not get blocked. You just have to not be malicious. You have to not be spouting nonsense or propaganda. And if you're just a straight up, honest, well-intentioned account on Twitter with 2 followers, you're all good. No problem. But if you're spouting nonsense and I look at your follower count and it's 3 followers, I'm just going to assume you're a bot or propaganda account and be blocked. But the only thing you have to do to not be blocked is basically don't be an a-hole, and you're all good. But it's become, because I do tend to be aggressive with blocking bots and propaganda accounts, it's become something of a running gag. There you go. All right, let's get back to the optometrist witness. This should be pretty darn good testimony here. So is there audio? Did I do something to the audio? I didn't do anything to the audio. Ha 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 ha. What's going on, folks? Oh, that's the computer. That's all right. Well, I don't know who this person is. And I don't know why there's no audio in the courtroom. No, I didn't change anything. So let me take a look here. If the courtroom were streaming audio, I should be getting the audio. But this is the fight outside the Dos Gatos. This is before the fight begins. There's Adam Amoya on the right there in the black hat. He's wearing the black hat on the right here too. He starts getting aggressive with the defendant. Bald head. There go the glasses. First, second hit, third, fourth, fifth, sixth, seventh, eighth. And that's when the gun comes out and the shots are fired. And Casado was backed up against the wall at that point. And the hands are still raised by Adam. He's still planning to deliver more slaps, clearly. But instead he gets shot at 7 times, real quick, 7 shots in 1.6 seconds, folks. I mean, it's not, pretty normal for, you see that all the time in competitive shooting, even with moderately skilled competitors. So nothing that remarkable, but they're all fired in quick succession. There's no long pauses where you can, had an opportunity to reevaluate the threat, and the threat had been neutralized, for example. And he did get the pistol into play pretty darn quick from wherever he had it holstered. Of course, now we know, I hadn't known this before, but that his job at the hotel was security. I wonder if what's happening right now is they're laying some foundation for this witness, and that's why the audio is off. I don't know. It's a little odd. And now this is frozen again. Oh. These, Jerry Mikulek is superhuman performance with rate of fire for sure, especially with those big revolvers he likes. I think this is the courtroom AV guy trying to get his crap.
I started biking running back towards downtown, so I ran towards the college. And I just heard 3 other shots.
All right, so we have audio back. Clearly, this is not the optometrist witness we were promised. This is some other dude, apparently an eyewitness to the shooting. So we'll go with this.
Where did you go from there?
After he showed, he ended up snapping. And that's when I threw my hands up all the way.
Where did you go from there?
After he showed, he ended up snapping.
Well, this is annoying, but what this looks to me, folks, is this looks like old video. This looks like it's possibly video from the first day of the hearing, which video was not shared with the public, so I don't have access to it. But the courtroom AV guy appears to be going through past video. Any dates here? I don't see any. Let me see if I can get past this.
My name, I heard a gunshot immediately, sounded like somebody was standing behind me.
All right, this is definitely old footage. This is footage from, we covered this a couple days ago, late last week. This is the medical examiner who testified the same day in the hearing that we're watching today, but earlier in the day. This was a state's witness. His medical examination testimony was very favorable, in my opinion, to the defense.
5 in total, and then finally superficial.
Then it looks like the court takes a break. All right, now, let's see. Now it looks like we're about to come back with the live witnesses again.
How about the other witness, 01?
Judge, we are making arrangements We're kind of stuck at a couple issues. One was prison, we have exit one tomorrow, so we're afraid on that. And then 2 out-of-town witnesses with flights, but we're trying to have the one from Tallahassee come early tomorrow. Just so, I'm not sure if we can get to noon tomorrow, but we can fill up the rest of the day for sure, so we'll get close to noon.
That's interesting.
And then we have a 1 o'clock right after.
Okay. I see. So maybe we'll start at 9 tomorrow. All right, sir, if you're ready to raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right, sir, if you're pulling around here, have a seat in the witness stand, make yourself comfortable. Go ahead and try to speak into that microphone for me. Everything we're doing today is being digitally recorded, so we need to get an accurate report. All right, yours.
Thank you, Judge. Could you state your full name, please?
Charles Samuel Miles.
And this may seem odd to you, but I'd like you to spell each of those names.
Jeez. CharlesSamuelMiles.
Thank you, sir. And what is your occupation?
Optometrist.
And what is an optometrist?
We correct visual problems.
And how long have you been an optometrist?
35 years.
And can you give the court a rundown of what your education was to qualify you as being an optometrist?
It's 3 or 4 years of undergraduate, followed by 4 years.
So, folks, while this guy's doing his background in education, which you have to have expert witnesses do to make sure they're qualified to be an expert witness, I'm going to go refresh my coffee.
Years of optometry school.
And where did you do your undergraduate?
Different state schools. I picked and chose since I was working as I was going to school.
I see. And what schools did you end up going to?
Daytona Beach State College and Palaca State College. It's St. John's River Junior College.
And the 4 years of optometry school?
Southern College of Optometry in Memphis, Tennessee.
And what years did you go to that school?
84, or maybe 83 to 87.
See. And that was basically a 3 or 4 year optometry school?
4 years.
4 years. And were you working at the same time?
Yes.
And do you have a business in St. Johns County?
Yes.
And tell the judge what that is.
It's a vision center. We do eyeglasses, contact lenses, treat different diseases.
And do you have a business also in any other county?
Palaca, Florida, same business.
And how long have you had the business in St. Johns County?
Since 87,
And how about in Putnam County?
maybe 88.
And tell me how many employees work for the company?
Doctors or just
Well, let's start with doctors.
6 doctors,
Doctors. And are any of them related to you?
all of them.
Okay. And tell the judge who that is.
The persons who are related to me, Dr. David, Henry, Jean, and Monica, and William.
Do you all play a similar role in the
Yes.
practice? And tell me what basically you do with a patient. I mean, how does that exam, could you explain that?
Patients come in with different problems. Sometimes it's diseases, sometimes it's eye infections, eye injuries.
Folks, the coffee is just Folgers from Costco. It's nothing fancy.
Sometimes it's driver's license patients come in. We do some tests for persons who are claiming disability. A lot of them are just persons who can't see, lost glasses, broken glasses.
What kind of equipment do you have to determine what a person's eyesight is?
We have autorefractors, we have eye charts, we have field machines, we have fundus cameras, we have it all.
And could you explain each one of those to me, what they do?
An eye chart, you try to get some idea of what a patient's eyesight is before you start. An autorefractor is an electronic machine that actually gives us a starting point of what type of refraction a person would need. Phoropters are actual, which is better, this one or that one. Fields machines, if sometimes you can't get a person to, well, if you suspect they have something else wrong with them, you'll do fields machines or fundus photos or OCTs. It's a lot of different machines.
And how many patients over the years do you think you've treated?
At least 100,000.
And is one of those patients Louis Casado?
Yes.
And can you tell us when you first recall being the doctor, the optometrist for Louis Casado?
When he was 4 or 5 years old.
And is there a chart that reflects your work over the years and his examination of him?
Possibly.
So this is a nice touch by the defense that they were able to get the defendant's actual lifelong optometrist, because it makes him look less like a gun for hire that's just giving testimony as the defense tells him to give it.
If they're over maybe 5 to 7 years old, some of those are digitized, but there's one out there somewhere.
Okay, may I approach, Judge?
You may.
I want to show you what's been marked for identification as defense J, and just tell me, leaf through that, it's 9 pages, and tell me if you recognize it.
If I recognize any of this, this last page is a page where we get handwritten notes and we send them to insurance companies or different other doctors.
What do those 9 pages reflect?
This is our eye exams. These are doctor's notes. These are also computerized notes sent to other doctors.
And for what patient?
For Louis Casado.
And can you give me an idea over what time period?
Over what time period these are? Well, the last one of these was a note sent to someone here, which was 2021. The first one is 2016.
So that would not reflect the entire record you have for your treatment of Louis Casado.
No.
And explain to me, and maybe you kind of did already, because the old days, you don't have those records anymore?
I still have them somewhere. I was requested to give 5 years of records for Louis Casado.
I see. Do you recall, though, when he was 4 years old?
Yes.
Tell me what his issues were and what you did for him.
I inherited Louis from either Nemours or Wolfson Children's Hospital.
Say that again, you did what from him?
I inherited him. His mother brought him in and said, I've taken Louis to Nemours, and they gave him glasses when he was 4 years old, and he won't wear them. So I'm getting a second opinion. And I've had him ever since.
And what was his issue, his eye issue at age 4?
He couldn't see, according to Louis. And I believe a pediatrician referred him to Nemours. Now, I'm not sure of that, but I'm almost positive that's where no one just I think Nemours has to be referred to get a patient in there.
Do you have a recollection of what his eyesight was after testing at age 4?
No.
Do you recall what you were able to do for him, if anything, at age 4?
We gave Louis glasses at 4 years of age, and he's been wearing them ever since, all day, every day.
And at what point do you recall, or does the record reflect what his specific eye issues are?
When did we know what his eye problems were? When the first time we examined him.
And what is the issue, though? What is his particular issue?
His issue at those times were astigmatism, and he always had little eye problems. I'm not exactly quite sure what it is, but he was very difficult to refract, which that means to get an accurate prescription when he was a child. I remember he was about 14 years old, and I said, Louis, I can finally make you see halfway decent. Took me 10 years.
Well, tell me what astigmatism is.
A warpage of the front surface of your eye.
And what does that end up doing to eyesight?
It gives you blurry vision both far and near, eye strain, headaches.
And I know I've read that there's particular angles with an astigmatism.
That's correct.
Can you explain that to me?
A warped cornea, most of the time, is either warped vertically, which is straight up and down, or horizontally. Some patients have that warpage at angles, which are oblique angles. One going this way, one going this way. That's the worst type of astigmatism to have.
And what type does Mr. Casado have?
Oblique astigmatism.
And do you have a recollection of what age he was when you were able to diagnose him with oblique astigmatism?
4 or 5 years old.
And do you recall what the corrective lenses were used at that early age?
The powers that he wore?
Yes, sir.
No. I know he is getting worse. It seems like every year up until about 4 or 5 years ago that he slowed down.
So from age 4 to about 4 or 5 years ago, he got worse just
Every year.
every year.
He comes in every year.
And when you say worse, what does that mean?
Higher power refractives.
And were you ever able to give him the diagnosis of his actual eyesight when it was uncorrected?
Say that again.
Well, I don't know how to artfully say this.
Mhm.
Somebody might be 20/20.
Mhm.
Somebody might be something other than 20/20. What does 20/20 mean?
20/20 is normal eyesight at 20 feet. Normal is it's just something somebody came up with 150 years ago. They said, this guy has good vision. Let's see what he can see at 20 feet. And they've been using it ever since.
And is that how far away at your office, and I would suppose most offices, the eye chart is away from the person viewing the chart?
Some eye charts to save space are actually shorter rooms. They're 10-foot rooms. And to simulate 20 feet, the patient looks at a mirror in front of him that the eye chart is projected behind him.
What about your office?
We have 20-foot rooms.
And based on your examination of Lewis at age 4, or at any age, just to be specific, what was his number?
The number of,
Was it 20/20?
oh, when he was younger?
Yes.
20/30, 20/40. We started getting some 20/20s out of Lewis when he was probably 13 or 14 years old. He was a challenge to get to anything better than 20/30.
What's the worst he ever got?
The worst corrected or uncorrected?
Uncorrected.
2200.
2200. And what does that signify?
That means a letter 10 times larger than a 20/20 letter.
And somebody with a 2200, are they permitted to drive, if you know?
No. 2070 is permitted to drive. If that's the best they can see is 2070,
Unless corrected, of course.
unless corrected.
So when you said the best we got him to was like 20/20, 20/30, you were talking about with correction.
With correction.
What can he see without correction at age 4?
It's tough to get uncorrected visual acuities at a 4-year-old. We have to use pictures. We say how many fingers. It's tough. I mean, some kids will go right through it. You put charts up there with pictures and they'll read it right off. Lewis struggled with that.
So somewhere in the record, there's an indication that one of the doctors had put 20/80 for Lewis a number of years ago.
Right.
Could you explain that?
It depends on how long you let a person study a chart, lighting conditions, how large your pupils are, how good they feel that day. If you let a person just look at a chart, you can always see better if you put letters up one at a time and let them study individual letters. Typically, we don't do that. Persons like Lewis, and I had 2 persons today that are very similar to Lewis, they don't even want to do it. The last lady I had before I raced over here, same kind of problem. I said, let's see what you can do without glasses. She said, don't bother. You know I can't see. So they don't even want to do it. I said, well, I got to go talk about it today. Let's see what you can do. 2200. I let her sit there for a while. I said, you can lean forward. You can squint. She goes down to 2100. That doesn't mean she magically got twice as good in 5 minutes. You just let them try harder.
So you're saying that someone can first look and you would think that they're 2200, if they keep looking, maybe?
Yeah, sure. Especially persons with astigmatism. They can, especially oblique astigmatism. You have 2 images to look at with oblique astigmatism. And the one image is blurrier than the other. But if you concentrate on one image and really bear down, mainly squint, Lewis has large pupils. He's always had large pupils. That makes your vision worse when you're out of focus. That's why you squint to see better.
So I notice you're wearing glasses. What is your eyesight?
Terrible.
Terrible.
Don't show me an eye chart.
Uncorrected, what's the number?
2400.
And do you have astigmatism?
Yes.
And how long have you had glasses?
3 years old.
Since you were 3. And have you worn glasses since you were 3 years old from morning to night?
Morning to night.
And what happens when you don't have your glasses?
Headaches, blurred vision. Once you get used to seeing well and never going without glasses, it's difficult to go without them. Unless you get into maybe 40 years of age and even younger persons. If they're just a simple, nearsighted, myopic person, I tell them to take their glasses off to read. Astigmatic persons, you really don't want to do that.
So what, at 2200 with an astigmatism as you described, what can Lewis see without his glasses?
You want to see a picture? I bought one. It's just off the internet. I mean, it's hard to know exactly what different persons, how they respond. Some persons can walk around with uncorrected astigmatism and won't even wear glasses. I get them from the driver's license place all the time. They say, I see perfect. I don't even need glasses. And they'll have astigmatism, but they never wore them as a kid. The persons who wear glasses all the time, they cannot do that. Once they take them off, their problems start almost immediately. You put them right back on. I've never went more than 2 minutes without glasses. I surf in glasses. You know? I got glasses in my dive mask.
The one note that said he was 20/80 at some point in the past few years, that still would not be legal to drive without.
No.
correction.
In fact, if you go to driver's license and cannot see 20/40, they refer you for an eye exam. If you get a person who's, let's say they have some sort of injury, if they can see 20/70, you can still get a license. Sometimes we regulate in the daytime driving only.
Have you ever heard of 2200 being considered legally blind?
If that's the best you can make a person see, that is legally blind. Now, that doesn't mean we do get persons that claim they're legally blind trying to get some extra Social Security, but that's only with no glasses on. They'll come in, they'll say, they told me I was legally blind. So not if you can see with glasses, you just need to wear glasses.
So I've also heard of the term nearsighted or farsighted. What is Mr. Casado?
He is nearsighted combined with astigmatism.
And what does nearsighted mean?
Nearsighted means better near than far.
So let's say at arm's length, tell me how well you think he can see with correction.
With correction, he can see 20/20 with
How
correction.
about without correction at arm's length?
That's a tough one. He can probably work his way through 20/30 if he really took some time and looked at it. Typically, a person like Lewis would have to come into around 14 or 15 inches to get 20/20. As you go further out, he rapidly falls off.
When you say further out from arm's length?
Right.
And when you say rapidly falls off, what does that mean?
Well, at half that distance, he would see, let's say he was 2200, at half that distance, theoretically, he could see 2100 at 10 feet. I've never checked Lewis's eyesight at 10 feet. We do 20 feet because that replicates distance vision.
Outside of the length of the arm, uncorrected, can you give us some adjectives as to how well he'd be able to see?
He could adequately see for short periods of time. He couldn't sit there and read a book. Well, he could if he wanted to get a headache in 5 minutes, but it's not recommended. If he was my kid, he'd be wearing glasses all the time, which he does.
What happens to the eyes, uncorrected, his eyes at nighttime? Is there any difference?
What happens to them at nighttime while he's obviously awake? The larger your pupils are, no matter what type of correction you have, the worse you see.
What about trauma to the head? Would that create any vision issues?
Yes.
Explain that.
Have you ever been hit in the face before? You'll know.
What about a person with poor eyesight such as Lewis?
Sure, it makes you worse.
What would you describe that?
If you're poor to begin with, you're not going to ever get better by getting hit in the face. Never.
And if someone was under fear, does something happen with the eyes as far as adrenaline? And
Your vision gets worse if you are out of focus, mainly because of dilation of pupils.
why is that?
Why does your vision get worse?
Yes.
Straight ahead light that comes into your eye is better focus than light that comes in from the side. So when you cut down a lot of side light, you can do it with your fingers, with a pinhole it's called. You can poke a hole in a piece of paper. I show it to kids all the time. So you want to see better, you poke a hole in a piece of paper. So look through this. They'll say, man, I don't need glasses. I just need a piece of paper with a hole in it.
Sir, at about 5 or 6 feet, uncorrected for Louis Casado, is the term blurry appropriate or some other adjective?
Blurry, distorted. Persons who do not have any astigmatism at all, then they can have blurry vision that is a lot easier to squint out, okay, because you use your eyelids. Persons who are out of focus at angles, they can't squint that vision out near as easily, mainly because your eyelids just go up and down. They don't go side to side.
So when we talk about, or you talk about the 2200, is that a number that is contemplating the astigmatism, or are those two separate concepts?
I don't get that one, Pat.
Okay, all right. Well,
You have blurry vision because you're out of focus. You can be out of focus for a lot of different reasons. Astigmatism combined with nearsightedness is one of them.
that's all the questions I have.
Cross-examination.
You had testimony about the records. You took those in?
I did.
Afternoon, Dr. Bowles.
How are you?
Mr. Mann went over some of those records that, some of those records that you, can you tell me, and those records document each time that Mr. Casado came into your business,
Right.
basically when one of the doctors, yourself or whoever else there,
truncated and corrected vision is normally written down.
Um,
Near vision, not so much on a younger person.
Can you tell me, Dr. Miles, what was the last date that Mr. Casado came into your office to have his vision checked prior to May the 28th of 2021?
Prior to May, it should be in here. 2018, I see a record. 2019, I see a record. 2016. So of course, I have many more records than that. This is 5 years worth.
Isn't it correct that the last date that that your office saw him prior to May the 28th of 2021 was September the 17th of 2019?
Prior to when I last saw him was 2019.
September the 17th. Is that correct?
Yes.
And when he came into your office, what was the vision that was reported at that time?
2080. That's from Hazy Davy, we call him.
I'm sorry?
2080.
Okay, you said something else I didn't understand.
That's my brother. I sometimes call him Hazy Davy because he's not the most accurate person in the world.
Okay, he's a doctor at your
Yes.
establishment, correct?
Hmm?
You employ him?
Yes.
Do you count on him to do this?
Yes. Unaided visual acuities. I asked him about this. I said, Hazy Davy, how come 2 years earlier Lewis was 2,200 and before that he was 2,200?
Stop there. I don't want you to tell me what he told you. I'm just asking you from these records, the last time Mr. Casado came into your establishment, the reported vision that he had was 28, correct?
Yes.
And your explanation today was that your brother, who was the one that saw him, didn't get it right?
Maybe he let him try harder. Just like the last patient I had this morning, or this afternoon, she went from 2,200 to 2,100 in 5 minutes.
Now, typically, when somebody comes into your practice, I mean, you want to, your goal there is to correct their vision so they can live a normal life.
Right.
And so you want to be able to be able to understand what their vision is without having to go through all that extra effort to try to make their vision as good as possible, right?
Right.
And the reason for that is because you don't, when you give them a prescription, they need to wear glasses, they don't have to squint or.
And that's why we take a lot more time doing final refractions to make them see off in the distance when we already know they can't see. We already know they need glasses. We don't have to sit there for 10 minutes trying to make them see as good as possible with no glasses. We know they need glasses.
So it would be, a typical practice would be to have them look at the chart, whatever it is, they're trying to get an idea of what their vision is without all the squinting or whatever it is to try to make it as good as possible.
That's the goal. Their final refraction is what we take the most time with. For normal persons who come in just complain of poor vision.
And in this particular case, it was reported as 28.
28. I wasn't there. I don't know what went on.
Right, but you're here to testify about the records from your business, correct?
Yes.
And you have no reason to believe that anybody in your practice would have or routinely make mistakes, correct?
Say that one more time.
You have no reason to believe that any of the doctors that in your employ, when they see patients routinely are making mistakes, correct?
Am I worried about them making a mistake?
That's
No.
not my question. My question is not whether you're worried about it, but is there anybody in your knowledge, in your practice, particularly your brother, who said that this one routinely is making mistakes?
No, he's fine. He's actually been doing eye exams for 40 years.
So he's got a lot of experience.
He knows what he's doing.
Okay.
While she's doing that, Dr. Miles, also on those records, not only does it record the vision of the patient at that particular time, but it also records the prescription that's being, when you're recommending a prescription glasses, what that prescription is going to be,
Right.
right? And so they would take that prescription, maybe you do that there in your office, maybe they go to a different location, but they would go and get eyeglasses
Right.
to help them see that prescription. Is that right?
That's right.
And that would give them as close to 20/20 as possible.
We try to give persons the best vision that we can. Sometimes it's not 20/20. I've had persons even today that were 20/70. That's the best they can see. But we try just as hard on the 20/20s as the 20/70s.
Yeah, Coach Ron?
Next.
Dr. Miles is showing you. showing you what's been pre-marked for identification purposes, states P. Is that the record we've been talking about, dated September the 17th of 2019? And is that a fair and accurate representation of that record?
Looks like it.
Your Honor, at this time, I'd offer this again as states next.
Objection here, say.
I'm sorry. You are objecting?
I'm sorry?
You say you are objecting?
Yes.
Okay. On the grounds of hearsay?
Yes.
Are there any exceptions to the hearsay rules in case of this particular document?
I'd be happy to lay that foundation, Your Honor.
I see prior to that 2080,
Sir, there's no question there.
Yes, sir, Your Honor. Yes, you may. Dr. Miles, I mean, in your practice there at Vision Center, is it a regular, I mean, you own that practice, right? So you're familiar with sort of your policies and procedures in terms of keeping records with your business, is that right?
yes,
And is it a regular part of your practice to record exactly what we've been talking about? Somebody comes, a patient comes in, you give them the vision test, you record their vision, you're recommending a prescription, you'll write those prescriptions down, that information, it's a regular part of your practice to record that and keep that as a business record, correct?
Right.
And is that what this is right here?
yes.
Thank you, Your Honor. We'd offer this in under the business records exception.
Any objection?
No, sir.
Be received as states next.
So the state's addressing this a record kept in the regular course of business, because that's one of the exceptions to the hearsay exclusion policy doctrine. So normally hearsay, a statement made out of court, introduced in court for the purpose of the truth of the statement. Hearsay is generally inadmissible unless it hits one of 50 different exceptions. And one of those exceptions is a regularly created business record, or a record created in the normal course of business.
Number two. States 12. Can you read it?
Yes. I mean, of course, the witness, actually, you have basically the same question, sir, to introduce the entire document into evidence. With the exhibit before you, 9 pages, is that kept in the normal course of your business?
Yes.
It's a business record?
Yes.
And is it a true and accurate copy of
Yes.
the business record? Judge, I would move this exhibit into evidence.
No objection.
Be received as, I've done this a while, so we'll just, that's 6.
Dr. Miles, you had said you treated Mr. Casado since age 4 through the years, but was there a break in time where you didn't treat him for a number of years?
I don't believe so.
How about when he went to college?
He came back. When he came back on break, he would come in.
I see. So you would be seeing him every
I think we saw him pretty much every year. It may be a year or two missed, but I don't believe so.
So the one record shows 2080. That's still a compromised vision, correct?
Yes,
And that still, with uncorrected, would cause blurriness, wouldn't it?
absolutely.
So really, as far as it being blurry, is 2080 or 2200? What's the difference?
2200 is obviously worse than 2080. But in the real world, you still need glasses if you want to drive anything other than a bicycle.
Well, on that one record, which you didn't do, your brother apparently did, was his prescription changed?
No,
So was his prescription prior to that? What was the last time you'd seen it before that?
his prescriptions in that time frame were very close together. That's what I was going to add. I just looked back, and when I saw him earlier, back in 2016, 2200, and then he magically went to 2080, and then 2200, the rest of the time.
And after this incident that occurred in May 28th of 2021, have you seen him after that?
Yes,
And did you prescribe glasses for him?
when he had his glasses broken,
Yes.
yes,
And what was that prescription for?
it was slightly worse. And then I saw him one time after that. That's not in these records.
Let me ask you, doctor, if we talked a little bit about light before and how that dilates and that can cause further issues with eyesight, correct?
Right.
What about the flash of a gun, the muzzle fire, that flash bright light that is associated with a gunshot? What would that do to the eyes?
It wouldn't help it,
Could it make it worse?
could make it worse.
Would you expect it to, or you have no comment?
I would expect it to make it worse depending on how close you fired a gun in front of you, especially at night.
At 2080, or even, well, let's go to 2200.
Hmm.
Can Louis Casado walk around this courtroom?
Yes,
Can he see images?
Yes,
Could he see your face very well at this distance?
he may recognize me, but if you and I both stood up here, he may not.
I'm going to show you a video, which is in evidence. Which is channel 9 from exhibit 2. This isn't on. Not that you're familiar with this video, but just to set this up for you, there's Mr. Casado on the right, standing against the wall. And I want you to watch while he goes over and picks up his glasses.
How long was that after a shooting? Immediately?
Well, I would say within minutes, 3, 4, perhaps. Take us out there. What I'd like you to explain is that something he would be able to see in the street?
Obviously, he found those, okay, but then again, that's the only thing in the street. He wasn't but 5 feet from them.
But that's consistent with
Yeah.
But it seemed to be important to you how far long after the event occurred. Why is that?
Because he's calmed down. And all you have to do for that couple of seconds or a couple of minutes is to sit there and look down at the street wondering where his glasses are.
And as based on your experience, what happens to an individual who has a 2200 and suddenly their glasses are off? What happens to their brain?
I'm not sure, Jeff, that seems to be outside of his expertise.
Sustained.
Oh, that's all the questions I have.
Any follow-up questions?
No, you're on.
Ms. Hood, be excused.
Yes.
All right, so thank you very much, sir. You are free to go.
See you later.
Thank you.
Happy guy, huh?
Because we are within minutes of Mr. Moody being here.
Okay.
I think the last I saw was text 409.
Take a 5-minute recess. Let me know. Mr. Hood.
I think.
Court's gonna be recessed.
All right, so it looks like we are going to get another witness. That other witness would be Charles Brian Moody, an accident reconstructionist. Charles Brian Moody. Yeah, fast forward this until we get to the point where he's on board. He can't be on very long. There's only about less than an hour left in this video stream. Let's see. Oh, there he is. All right. All right. Before I bring him up, though, let me take a look and see if we have more questions that need to be addressed. Let's see. Law self-defense member. By the way, folks, all the members, law self-defense members get to ask their questions at no charge whatever. They simply get that question access as part of their membership. That membership is normally under $10 a month, about 30 cents a day. And right now, you can, in fact, become a law self-defense member on a trial basis for only 99 cents for 2 weeks. Gives you unlimited access, just like every other law self-defense member. If you decide you don't like it within that 2 week period, just let us know. Cancel. We'll give you back 200% of your money. It's literally a zero and negative risk opportunity. And if you just stay a member, it's 30 cents a day, roughly. Moving forward from there, less than $10 a month. And as a member, you can pose as many questions as you want in the member chat for any of our live streams, and I will answer them. If you're doing this on YouTube, and you want to ask a question on YouTube, it's got to be a $5 super chat, folks, per question. So if you ask 2 questions as super chats in the course of a month, you could have just been a member and asked as many questions as you wanted. And you can take advantage of that trial membership for 99 cents at lawofselfdefense.com/trial. So let's see. Law self-defense member Josh says, I have an interesting self-defense self-defense case happening in my town. 2 guys at a gas station got into it, one with a crowbar, one with a gun. Guess who's on trial? Yeah, presumably the guy with the gun. Yeah, I'll keep my eyes open for that, or send me a link. I'll take a look at it. Let's see. A law self-defense member, Don, says a bill was introduced today in Idaho to add a provision for reimbursement of expenses if a defendant is acquitted by reason of self-defense. As explained in the hearing, upon acquittal, the judge will be able to decide whether the defendant will be reimbursed. Okay, good idea. We have a lot of bad prosecutions of self-defense cases, folks, and the prosecutors need to be held accountable, or at least the system held to be accountable when they bring these BS prosecutions in apparently clear cases of self-defense, or cases where there appears no way that self-defense could or would be disproven beyond a reasonable doubt at trial. Let's see. Law self-defense member asks, does the experience of being attacked with deadly force by blunt objects, cutting instruments, and firearms, in that order, is that sufficient to qualify you to testify as to the physical and mental effects of such force upon the body? Well, you know, the truth is, Donnie, what makes someone an expert is in the discretion of the judge who's making the call. There are a couple of generalized legal standards that are applied in federal courts and state courts. The most common now is something called the Daubert standard, and you would have a Daubert hearing to qualify someone as an expert. It looks like a variety of elements, how academically verified the expertise is, how many times the witness has published, what degrees they have, is it widely accepted in the community of experts in that field. A lot of variables, but at the end of the day, it's up to the judge. I mean, I've seen cases involving a manslaughter case that involved, one of the elements was the speed of the vehicle involved. The vehicle had been observed racing down the street by a couple of eyewitnesses, and they were allowed to testify as to their opinion as to the speed of that vehicle as it went by them as experts. And you might think, well, they don't have radar guns in their eyes. How would they know what the speed was to any degree of expertise? Well, it turned out their hobby was going to a local racetrack, a drag strip, and they would bet each other on the speeds of the cars as they went by and then verify that speed with the display at the track. And the trial judge said, well, that's enough for me. You're qualified as an expert in calling the speed of a vehicle as it goes by you. So it's really ultimately in the hands of the judge, just like any other evidentiary call. But if all you have is your own personal experience, the attack, of course, would be, well, just because that's your personal experience in one instance or a handful of instances doesn't mean that other people generally would react the same way. Let's see. Law self-defense member Kyle asks, why should I pay approximately $7 to make a super chat of $5 and pay YouTube 30% of that versus joining here and having a self-paying chat and all goes to law self-defense? Excellent question, Kyle. Nobody should do that. Don't do the super chat route, folks. YouTube takes a third of that money, costs a minimum of $5 for less than $10 for an entire month. And we do live streams most days of the week. You can ask as many questions as you want. Get your trial membership at lawofselfdefense.com/trial for only 99 cents. Stay a member, and it's still less than $10 a month. That's the only option that really makes sense. All right, let's check out the super chats. And I think we're all good there. All right, so let's get back to doing the next witness, which is Charles Brian Moody. He's an accident reconstructionist for the defense.
Swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Step up here on the witness stand, make yourself comfortable, and try to speak into that microphone.
Thank you.
Thank you, Judge. Will you state your full name?
My name is Charles Brian Moody,
And could you spell each of the three names?
Charles Brian, Moody, Moody.
And what is your occupation?
I am a principal mechanical engineer with Applications Engineering Group.
And what is the application engineering group?
We handle mostly forensics related cases, but it's an engineering firm in Atlantic Beach, Florida.
And how long have you worked there?
This guy
I've
looks.
been with AEGI since 2006.
And what are your chief duties with the company?
I'm a mechanical engineer. Most of my time is spent doing analyses on various sorts of cases, including car accidents and things like that.
Doing accident reconstruction?
Accident reconstruction, yes.
And tell me what your
This guy looks very, very familiar to me. I feel like I've seen him testify before, but in all fairness, most mechanical engineers look like some variation of this theme.
educational background is.
I have a Bachelor of Science in Mechanical Engineering from the University of Florida,
What year did you get that?
2003.
And how about a master's degree?
I do not have one now.
Okay. And do you have any particular certifications?
I have some certifications in the areas of accident reconstruction mostly.
And what kind of certifications are those?
For learning certain equipment and software, crash data retrieval.
Hey, if you're watching this on YouTube, folks, hit that like, thumbs up button. We're falling behind on the likes again. Don't make me shut down the stream early to YouTube. And if you could subscribe, that would also be greatly appreciated.
Things like that.
What does that mean, crash data retrieval?
Oh, crash data retrieval.
Crash data.
It's a system for retrieving information from the airbag systems after an impact to a vehicle.
How many cases over the years do you think you've worked on as far as trying to reconstruct accident sites?
Hundreds.
And does that include the use of what I know of as a Faro scan?
Yes, it does.
Okay, and could you explain what a Faro scan is?
Sure. Faro scanner is, we'll see some photos of it here in a minute. It's a device that we put on a tripod that has a laser and a mirror that spins. So it takes an array of points, hundreds of thousands of points per second. So it accumulates millions of points. But as it spins and the unit rotates, it takes slices of whatever it can see in 360 degrees in every direction. So for instance, if I set it up here in the courtroom, it would scan everything that it can see. And while it'll catch the podium you're standing in front of or behind, but what's behind that, it wouldn't see. That would be in a shadow, so to speak. So what we'll do is we'll take the scanner and we'll place it in multiple locations. So if I placed it in 4 or 5 locations around the room, it would fill in all of the blanks. It would start to fill them in. So what you'd end up with.
So you may recall, if you followed me when I was doing the Dean Cummings trial, that was the New Mexico trial where Dean Cummings was living in a cabin on some land he was thinking about buying in New Mexico, got into a confrontation with the gentleman who owned the land and shot and killed that other gentleman inside the cabin, claimed he did it in self-defense, was acquitted in that trial. They used a similar device. Also in the, maybe I'm getting that wrong. Maybe it wasn't that one. I can't recall now if I'm confusing that one. I know they did use it in the Aaron Dean trial that we just did out of Fort Worth, the police officer who shot and killed Tatiana Jefferson. They used a similar device on the parts of the exterior of that home to kind of, it scans an area and then develops like a computerized 3D model of that space. That's what he's talking about here.
Is multiple scans, and each of which can be registered to the other scans. And ultimately you end up with like a 3D environment that is accurate and scaled, overlaid with digital photography that the unit also utilizes to build a virtual environment that is accurate to where it's been, to the area that's been scanned.
I see. And what were you, how did you get involved in this case?
My assignment in this case was to map the area of St. Augustine where this subject incident occurred.
I see. And who actually?
No, that was your office, command law.
And were you able to conduct an investigation of the scene?
We were, yes.
And you have a date that you did that?
I don't know off the top of my head, but I can look. We performed our inspection on January 12th of 2022.
All right. Thank you. And did you use a Faro scan on that particular day?
We did, in addition to a couple other methods.
And what were the other methods that you used?
In addition to the Faro scan, which is our higher tech tool for mapping a scene, I also used my total station surveying equipment, which is a similar technology, but only shoots one point at a time. So this will be shown in the, explained a little further in the slideshow. But it was used to map several distinct points in order to validate the scan. In other words, it's another method to get the same measurements, but doesn't include as much detail. We did that as well as a low-tech method of simply laying out a really long tape measure along the sidewalk and noting specific control points, and just for seeing the distance between those points and using that to further validate the scans.
And would some photographs assist in showing what you actually did on the street?
Yeah, I took a lot of photographs, mainly to show each points where they were in relation to each other and what those measurements were.
And how many photographs approximately did you take?
I took 160 photographs.
And we're not going to go through 160 photographs, but have you picked out some that will demonstrate what you did that day for your analysis?
We have, and there's some explanation that goes along with them. I'll tell you what they
Judge, may I approach the witness? You may. I want to show you what's been marked as a composite exhibit H and tell you to look through that. First, there's a disc on top of the composite. Can you explain what that is?
The disc includes the raw scans that we took through the Faro program.
All right, and what are the photographs? You lead through them and they're numbered. I'd like you to describe them by number.
Okay. The first is a overhead scale diagram with my notes on it that I used at the inspection itself. And
Okay, my mistake. That's the only one that's not numbered. How would you
Okay.
describe that? How is that described on the first page?
it's Faro scan notes.
And is that seem to be an accurate and true copy of what your notes were?
Yes, that's correct.
And now go to the number photographs.
Okay. Faro position 1.
Why don't you lead through and then tell, I think, let's use it as a composite to see if you think the photographs are a true and accurate depiction of the photographs you took on that day.
Yeah, while he's doing all this, yeah, the New Mexico case with Dean Cummings, that was the case where actually the police completely fumbled the investigation, didn't properly measure anything. So that's what I was thinking there. Then I just got it flipped. It was the Aaron Dean case in Fort Worth, Texas, where they used a scanner for this purpose.
They are, along with additional notes pages and
And the
scale
Faro
diagram.
scan, you had an opportunity prior to coming here before to review the Faro scan itself, the disc itself.
I've reviewed the Faro scans. I haven't seen this disc until now.
Was the Faro scan that you produced the true and accurate copy put onto a disc?
Yes, that's correct.
Or Judge, I would move composite H into evidence.
Any objection?
I need to see what it was. Let's start. Start on that. I think he sent you the PowerPoint.
No objection. Have you received that defense case number exhibit?
I need that copy. 7 forward.
We're, Judge, may we now publish? So this, Mr. Moody, is the first page which you described as the Faro scan notes. And tell us what we're looking at.
Okay. First of all, this is an overhead image retrieved as satellite imagery. Up in this photograph is north. The yellow initials that you can see over some of the buildings on the north and south side of the roads.
So presumably, folks, this is showing DG here in the upper middle is Dos Gatos, the bar out in front of which this fight happened. Over here to the left, SO apostrophe H is presumably Scarlett O'Hara's, an adjacent bar next door that there was some testimony about. And these would be various, the X's would be where various people are located at various times, I suppose, in the actual fight itself.
It's Scarlett O'Hara's, Dos Gatos, and Schmegel's Bagels. I just use initials just because I'm using them primarily as my own notes while I'm working. So it's kind of shorthand everything. The yellow X's, which are added, I believe there's 5 of them. Those were initially what we'd planned to do for the Faro scans. We had them in the middle of the road. They take about 10 minutes per scan. And I did not realize or know which, I know some of the roads in the area are pedestrian only. Turns out there's actually some decent traffic on this road. So we didn't want to hold up traffic. So we modified it in the field and actually did about twice as many scans as we planned. The blue X's are the actual scan locations. There's 9 of them and they're numbered 1 through 9. We ended up going on either side of the road in order to split the area that we wanted to get down the center of the road. We added a scan location more or less directly underneath the subject camera at Dos Gatos. And Schmegel's Bagels was closed and their courtyard gate was closed and locked, and we didn't want to go in. We didn't have permission to enter their property. So it simply scanned from their fence line, but it was more than sufficient to get what we needed.
Is this the area that I asked you to do your analysis?
That is correct, yes. Go ahead.
Go ahead.
Further, the yellow circle in the road was the initial intended location for setting up my surveying equipment. Again, it was not able to be set up in the middle of the road due to the traffic. We just moved it to the side, but as long as I can get to a point where I can have a line of sight to see all the points I need to shoot, it works perfectly well. It's well within its range. The blue lines, there's sort of a V, they're kind of hard to see, but those show the extremes of what can be seen by the cameras, the subject cameras with the 2 videos. And I think that's it for that slide.
The fact that you weren't able to go into Schmegel's or put your survey equipment in the street, did that compromise the result, the detailed result of what your intention was?
No, not at all.
All right, we go to the next slide. What is Faro position 1?
This was, I numbered the Faro positions that we used 1 through 9, just arbitrarily giving them identifiers. This is on Hypolita Street, facing south, looking into Schmegel's Bagels patio is directly behind the Faro scanner. It's hard to see the tripod. It's dark charcoal gray with the blue, the blue unit on top of it. That's the Faro scanner itself that rotates.
And it's your understanding that there was a surveillance camera behind the fence?
That's correct. In this shot, it's kind of next to the tree, near where that it's like a wind chime. It's in that area, correct?
By the wind chime?
Correct. It's behind the wind chime. I think it's mounted to the wall of the building, but it's well within the line of sight of the Faro scanner.
Anything else about this picture that's important to tell the judge?
No, I can go to the next one.
Faro position 2.
Still facing south, looking at the Schmegel's patio, which is on the right. It's just a little further east. Same thing, just a slightly different perspective. Wanted to note the position of the bench on the left side of the screen. During our scan process, during scan number 5, I think we realized that the bench had been moved relative to its original location, which we can see in the subject videos. So we've moved the bench back to approximately its location. Now what that would result in is ultimately, since we did 9 scans, is same thing if we use this courtroom example. If I were scanning it in here and someone moved a chair from one location to another, we would just end up with both of those chairs in the composite image that we ended up with. So you'd have, ultimately in the scans, you have 2 benches instead of 1, but they weren't really pertinent to anything we were looking at that was of importance.
And how did you determine where to move the bench to?
We have, in one of the later slides, I have a close-up that shows that, but we could see an anchor point in the ground that looked like it was appropriate for the bench, and it was approximately where it looked like it should be based on the video.
Let's move to Faro position 3.
Yeah, before.
Actually, this is position of camera.
Right, this is before position 3. This is just a closer up shot so you can see the camera itself. This is facing southwest, looking into Schmegel's patio.
Next slide. which is fair position 3.
Correct. This is, again, facing south. Schmegel's patio is to the right. It's just a little further down the street.
Next slide. Fair position 4.
Position 4 is more or less across the street from the previous position. This is turned around the other way, facing north, looking at Dos Gatos.
Next slide.
Oh,
Fair position 5.
I'm sorry, can we,
Yep, go back.
no, this was we've modified the slideshow to move
Oh, I'm
the
sorry.
banner on position 4.
Go back to 4, please.
The Dos Gatos camera is actually behind the heading banner above that, above the door. Do we want to go to the other slideshow? Sorry.
I guess I'm confused, because I thought this is the one we put in order. I think the only thing to do is, you tell us what slide you want to do next.
Well, no, it's not in the wrong order. I show you.
Okay?
We
I'm sorry. Could you, let me approach Judge?
You may, but I mean, I think there's a stipulation that the camera is where it is. Do we need to do that?
Well, there were other modifications that we did to the slideshow for similar reasons.
Yeah. Well, let's just go through what we have and you just
Okay.
explain what we have.
Okay.
Let's just move on to the next slide. Can you explain fair position 5?
Okay, fair position 5 is only a few feet away from position 4, but position 5 is specifically positioned as close as practical to underneath the camera from Dos Gatos.
Surveillance camera at Dos Gatos.
Correct, yes.
Next slide. 6.
Position 6 is still facing north, looking at Dos Gatos on the right, and Scarlett O'Hara's is to the left.
7.
And this one, we're looking down the street, west, down Hippolyta Street, with Schmegel's Bagels on the left and Scarlett O'Hara's on the right. And to the right of the screen, Dos Gatos is not in the photograph, just helping with getting bearings. And in this photograph, you can note the position of the bench. In the prior location of the bench, it would have been just next to these garbage cans on the left. And as you can see, it's been moved further down in front of the fence at Schmegel's.
Is this where it was the night of the incident, or was it?
Approximately, yes.
Next slide. Fair position 8.
Okay, for position 8, we're a little further west, back to facing south, looking across Hippolyta Street. You can see Schmegel's Bagels patio to the left, and again, the bench in its subject location.
Next slide. Position 9.
Now we're facing east, looking down Hippolyta Street with Scarlett O'Hara's. And
It really would have been helpful here if before each of these photos, they showed an overlay, like an overhead view of the street, again, highlighting on that map view where each of these cameras were, because it's getting very disjointed the way they're doing it here. It becomes difficult to follow where each of these is supposed to be taken from.
Dos Gatos on the left.
Next slide.
This is the bench position where we moved it to. And the next photo, I think, is the important one.
Next slide.
This is what appears to be an anchor bolt in the sidewalk, indicating that's likely where that bench is intended to be, but it wasn't bolted down and not terribly heavy, so it doesn't surprise me that people move it around.
Next slide. What does this indicate?
So these are possible control points this image was initially supplied to me by the biodynamics engineer, along with the yellow X's that are kind of hard to see, but they're along the intersections of the concrete joints in the sidewalk and on other specific points that could be easily pinpointed in the scans and used as reference points.
This slide is entitled Possible Control Points.
That's correct. That is the title that with this image, which is a screenshot from the Dos Gatos camera, it was sent to me with the possible control points and this title on it. And I used it as a notes sheet when I did my inspection. I added the blue pen marks on it, numbering the points. I think I went 1 through 12. Those are just identifiers. 1 through 8 or 9 is kind of along the right, looking at it from this point of view, along the right side of the road, just at the joints in the concrete. Point 8 is up near the top center of the screen. Just a couple of points that I'm going to reference in the next couple of slides. Point 10 is over on the left side of the screen, and point 12 is kind of in the middle of the road. It's along one of the storm drains, at the corner of one of the storm drains, sorry. And you can see at the top of the screen, sort of on the left third, is the bench in its subject location.
So did you use this particular picture to replicate when you move the bench?
Yeah, that's correct. More or less, it appears that that is approximately where it belonged. So when we moved it, we saw the anchor points. It seemed to fit. It was close enough.
Next slide. Station 10.
Okay, so moving to the lower tech methods of measuring. We use the total station to map some of the points that I mentioned before. 8, 10, and 12 were some that I gave examples of. This photograph, the banner is actually covering the chalk mark, but there's a concrete joint and it has a chalk number 10 next to it. And you can see in the top center of the screen, the yellow tripod, that's where I set up my total station equipment.
So this is, we're no longer doing.
All right. I mean, this is kind of silly, isn't it? It's totally unnecessary for this identifying banner to be this large to the point where it's obscuring in the image things this expert wants to refer to. I mean, they could just have little words in the corner of the image. Why do they have this full width, thick white banner that's blocking things that are apparently relevant in the image? That's just bad form.
Doing the Pharaoh positions. This is the total station, which would be the tripod that we see.
That's correct. And that uses the laser to map areas one point at a time.
And is this the cross-reference with the Pharaoh scan?
I use this to validate the Pharaoh scans. We wanted to pull measurements of specific points, so I can tell you, we can pull, it'll give you X, Y, Z coordinates relative to where the center is of the tripod. And those can be used to measure distances between the points. One could then go into the Pharaoh scans and verify that they're the same.
Next slide. Points 10 and 12.
So this is facing southeast towards Schmegel's Bagels again with the total station tripod in the top of the screen towards the right. And at the closest point of that sewer drain grate, that's point number 12. You can see the chalk mark that I added, and over to the left of the screen, that's point number 10.
I mean, frankly, what would make me most concerned here is it's almost like this guy's surprised that the banner's covering up relevant points in the image. Like, was there not a dry run here? I mean, why wasn't this issue spotted before these things were presented in court as evidence?
I used chalk to mark them so we could see them in the photographs. It'll wash away. I didn't want to paint the roadway. And small reflective stickers just to put on the point itself that makes it easier to shoot with the laser, which are easy to clean up, not leave any mess behind. And I think that's it for the total station.
Total station points on scale diagram.
Okay, so this is ultimately the product of the total station. Well, aside from having the list of points in their X and Y and Z coordinates, when plotted into an AutoCAD program and overlaid with a scale diagram, we can line everything up. Points 1, 8, 10, 11, and 12 are noted as some of the more important points that I just grabbed, which are just points in space that had photographs of, so they're easily identifiable. I also noted a couple of sewer caps for reference, which help to just align everything up so you can verify that we have everything aligned properly on the scale diagram. The Dos Gatos camera is at the top center of the screen. The Schmegel's camera is actually off the screen. That was one of the modifications. It's in this image just south of the edge of the screen. And the total station tripod location is kind of to the left of the tree on the sidewalk. It's three-pointed, looks like a Mercedes-Benz logo. Yes.
This is when you move to physical measurements.
That's correct.
This is just the third process to try to verify the information.
Sure, this is the lowest tech method of just laying a tape down on one of the concrete joints, numbering, well, some of the numbered joint intersections were already there, and just took some photographs to show the distances between physical points with a tape measure, just a low tech method of measuring things. And this is just a close up of one of the points to show what was provided in addition to an overall photo to show where that point is. This is a way to close up show what the measurements are.
And this is entitled physical measurements in point 8 detail.
Correct.
Next slide. Okay, this is the last position of the camera, who's got this.
That's correct. This is the last slide, just showing a survey pole next to the camera itself to show its height above grade.
So can you tell the court, as far as the Faro scan, each particular spot that you were shooting from, what's the terminology for what kind of accuracy that you're getting in measurements from the Faro scan?
In any individual point that it shoots, and again, there are millions, the accuracy range listed on that device is plus or minus 2 millimeters for this range.
2 millimeters. And what's that in relationship to an inch?
2 millimeters, a little less than 1/8 of an inch, I think.
So what's the final product that you end up here with when you put all the three processes together?
Once everything's registered together and the different scans are combined, since the objects in the area are scanned from multiple directions, you will have three-dimensional objects in a three-dimensional environment space, and you can rotate it, you can pull measurements from it, you can it's a three-dimensional virtual world.
And were you able to put it together, and you believe that it's a true and accurate description of the street there in front of Dos Gatos?
Absolutely, yes. We processed the scans and registered them together, and I provided that to the biodynamics engineer along with the raw scans if he wanted to run the program himself, but it's pretty much plug and play.
And all that is within 2 millimeters of accuracy.
That's correct. Individual points and things that are scanned are plus or minus 2 millimeters.
And the product that you ended up creating, did you then deliver that product to an individual in California?
That's correct.
And who was that?
His name is Paris Ward. My understanding is biodynamics engineering.
And tell the court what your communication was with him.
Initially, there was some back and forth just to make sure that we were going to get everything that he needed. So with planning out where we were going to set up the Faro scans, we discussed that. We both looking at the same overhead image, looking at the screenshots from the videos, and he suggested where we should scan. I had the same idea anyway. We agreed. And so when we did the inspection and I had to modify that to stay out of the street, we ended up with almost twice as many scans as we needed, but it covered everything that was necessary.
So you consulted with Mr. Ward before you even did your analysis on the street?
That's correct, yes.
He indicated what he was looking for, and you both apparently agreed to what was needed.
That's correct. We were on the same page.
And you transferred all that information to Mr. Ward?
That is correct, yes.
I don't have any other questions.
Cross-examination? All right, may this witness be excused?
Yes, sir.
All right.
Thank you.
Have a good day. All right, let's see, 2 minutes go by, we're breaking point. Why don't we,
I think we could take up most of the morning, but I think would work probably best.
All right, folks, that looks like that is it. That is it for today on this trial. So I'm going to head over and see what questions have come in before we wrap up the show. If you'd like to submit questions, now would be the time, either as a $5 super chat or as a law self-defense member in the member chat at no cost whatever. And that's it. No cross-examination of that guy. His whole point was just to provide geometric measurements of between objects and presumably people, spaces, locations in the street. Distance is, relevant here. This was an impact fight, a barehanded attack fight until, of course, the defendant went to his gun, and then the distance at which he's firing his shots is relevant. We'll have to see. Presumably, this will be evidence that will be used in a more narrative sense when the defense does the equivalent of their closing argument to the court. And tomorrow we'll continue with the additional expert witnesses. Again, we have a whole bunch of them coming up. So far we've heard from the optometrist, the accident reconstructionist. Next, we'll have a forensic video analyst, a couple other lay witnesses, one of whom is a corporal, so a police officer. And then we'll hear from Roy Bedard, a use of force expert witness, Dr. Deidre Leak, a facial plastic surgeon, and Dr. Lawrence Miller, a psychologist. So a lot of expert witnesses for the defense. It looks like about 6 in all. That gets expensive, folks. Before I get to the questions, I just want to mention again, this April, we're doing one of our relatively rare, we only do this class once, sometimes twice a year, Law of Self-Defense Advanced course. This is our live streamed Law of Self-Defense Advanced course covering comprehensive instruction on self-defense law applicable to all 50 states. We cover the 5 elements of self-defense. We cover defense of others, defense of property. We cover interacting with the police in the aftermath of a use of force event. Spend almost an hour on that alone. So if you've ever wondered, how should you engage with police officers if you've been compelled to defend yourself? That would be the time to learn what you need to know. We cover how the criminal justice system really deals with self-defense cases, what prosecutors look for in assessing whether they want to bring that particular case to trial, so you know what not to do in a case of self-defense. We do all that in one day. One day. It's a full day course, but it's all in one day. This one is Saturday, April 15th, 2023, tax day. And the good news is if you sign up this month for that April 15th class, it's 50% off the normal registration. Save yourself $100. If you sign up for that class in February, it's still discounted, but only 25%. If you sign up for the April class in March, it's only 10% off. And of course, if you sign up in April itself, it's the full price of the course. So if this is at all of interest, I would encourage you to register sooner rather than later. And you can do that at lawofselfdefense.com/advanced. Also, don't forget, you can get your free copy of The Law of Self-Defense Principles. This is our best-selling book. Check it out on Amazon. Over 1,200 reviews, 5-star rated, but don't buy it there. They'll charge you $25 plus shipping and handling. We'll get you the book for only the shipping and handling. We'll eat the cost of the book. You can get this at lawofselfdefense.com/free book. And I think, and just to remind everybody, this Friday, 1 p.m. Eastern time, we will have the defense lawyers from this hearing, Attorney Dan Hilbert and Attorney Pat Kanan, on as live guests on our live stream Friday, January 20th, 1 p.m. Eastern time. That's one day after the appeals period for the state on this immunity grant has expired. So on Thursday, the state loses the option to appeal this grant of immunity. On Friday, these attorneys have agreed to come on to educate all of us with their perspective, the in the trenches perspective in winning this grant of self-defense immunity for their client. So join us then. Mark your calendar. All right, so let's take a look at the questions here. Let's see. Josh had commented on a self-defense case in his neck of the woods. Josh, if you have a link to that, you can send it to support@lawofselfdefense.com and just put in the subject line or something forward to Andrew, and they'll make sure I get it. Law Self-Defense member Joe asked, did the defense produce their own version of the expert slideshow, and are we looking at their version with the banners? I don't know the answer to that. The expert never said these were not his slides. I don't understand why the defense would do that and then not pass them by the expert again to make sure that the slides were still effective for the expert's purposes. But maybe we can ask on Friday. I keep that in mind for when the defense attorneys are here. We can ask them. Let's see. All right, that's it for the Law of Self-Defense members. Check on the super chats, and we don't have any more super chats, which is fine, of course. All right, folks. So we will come back tomorrow, beginning with day 3 of these hearings. Again, these self-defense immunity hearings occurred in mid-November. The grant of immunity was handed down by this judge on December 30th of last year. So we just finished day 2. We'll begin with day 3, a lot more expert witnesses from the defense, and we'll proceed from there, probably starting again tomorrow, same time, 11 a.m. Eastern time, 9 a.m. where I live. And it'll probably be most of a full day tomorrow covering this stuff so we can get caught up. Until then, I remind all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. You also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.